Today I will give you a brief overview of Rule 190 of the UPC Rules of Procedure, which governs the production of evidence during pending proceedings, in comparison, for instance, to the inspection proceedings according to Rule 192 and at SEEK. The legal framework is pretty much straightforward. Rule 190 RoP implements Article 59 of the UPCA and establishes the court's power to order the disclosure of evidence that is under the control of the opposing party or even a third party. It complements Rule 172, which makes clear that each party must first produce the evidence available to support its own case. Rule 190 then complements this principle by allowing a party, under certain conditions, on which I will elaborate further down the line, to obtain evidence that is outside its own sphere of control. Finally, the Articles 3 and 6 of the Enforcement Directive remind us that any disclosure must always be necessary, proportionate, and strike a fair balance between the parties. So, what's the purpose of Rule 190? To put it in the words of the Court of Appeal, Rule 190 provides us with tools for carrying the burden of proof. This means, in particular, that it's designed to address situations of evidentiary asymmetry, where crucial information is available only to the opposing or a third party. Typical examples include internal testings, technical documentation, supply agreements, system logs, and so forth. At the same time, and this is important to stress, Rule 190 is not intended to reverse the burden of proof, cure an insufficiently substantiate claim, or introduce an US-style discovery. Rather, it complements, as already mentioned, but does not replace a party's own obligation to investigate the facts and produce the evidence reasonably available to it. That brings us to the requirements of a request under Rule 190. The first requirement is that the requesting party must establish a prima facie case. The party must, and that means prima facie, present reasonable available evidence supporting its allegations. Mere assertions are not enough, but neither is conclusive proof required. The case law consistently shows that applicants are expected to exhaust publicly available sources and document their own investigations or efforts for investigations before asking the court to intervene. That means also, for example, not only free publicly available sources, but also, for example, information behind paywalls. There was a case when I think it was about streaming portals, where the court explicitly ruled that it's would have been within the responsibility of the applicant to also go down that alley. The second requirement is that the requested evidence must be specified and it must be under the control of the opposing party or a third party. That means like shotgun or scattershot-like motions, like any documents relating to all agreements on XYZ and so on is not sufficient. But it's on the other hand enough that you prove that this evidence existed or exists and is in the control or within the control of the other party. That means like if you have document like technical specifications that are commonly known to exist with regard to, I don't know, some processes because it's within the legal framework to produce such documentation, then this is enough. You don't have to like specify it in a way of, okay, there is file number XYZ within, I don't know, this or that department of the opposing party. The third requirement concerns confidentiality. Rule 262A provides the court, as you might know, with a range of tools, including redactions, confidentiality clubs, and so on to protect sensitive business information. Why is this to mention? This is to mention because like this is a trade secret argument. Doesn't help you if you are on the opposing side, but I will come back to this in a few seconds. Finally, the court will consider necessity, proportionality, and timing. It will in particular ask whether there are less intrusive means of obtaining the evidence, like, for example, own tests, whether the request is proportionate in scope, and whether the likely evidentiary value justifies the burden imposed on the responding party. Timing is also important. Rule 190 applications, and this was also explicitly ruled by the court, can be filed at any stage of the proceeding, which means they can't be too late, they can't be too early, but if you are on too early or too late, this might have consequences like the court ruling, for example. We don't know if this fact is already relevant at this stage, or maybe its relevance depends on other questions at stake. For sure, you also have to keep in mind the narrow time frame of UPC proceedings. So at a certain point, although there is no case law regarding this, court might also say, okay, this will like overstretch the time frame of the UPC proceeding or foreseen for UPC proceedings. So what are the practical takeaways of this brief overview? In general, Rule 190 is a powerful procedural tool, but is not a substitute for own investigations. It explicitly does not allow so-called fishing expeditions, but only is a tool for bridging evidentiary gaps. In German, we have this word Beweisnot, which can roughly be translated as lack of evidence or lack of access to relevant evidence. For applicants, it is therefore highly recommended to begin with an internal assessment of all reasonable available evidence, as already mentioned, own tests, research, public sources, not limited to public domain in the sense of it has to be free. This is also a question of proportionality. Also, what is again and again stressed by the court, you should not like leave it to the court to find out which points of the procedures are those addressed by your request. So what do you want to prove, and so on and so forth. The court explicitly rules that you have to draft a narrow, concrete, and self-explanatory request for 190 decision. For respondents, on the other hand, you should also always try to tackle the lack of plausibility, the lack of specifications, the already mentioned scattershot approach, and maybe also the question of proportionality, which means like, is it really at this stage of the proceeding relevant, for instance, to put so much effort in producing this particular evidence? And what is also important, and that brings me back to Rule 262.8, you can always be hit by such a Rule 190 application. So therefore, it's highly recommended to have a confidentiality strategy at hand for such cases if you consider it likely to be sued out of unitary patent. The trend in case law, maybe you have already heard this out of my words, the requests under Rule 190 are not granted as a matter of course. They have the court, both at first instance as well as on appellate level, has emphasized that it has a wide margin of discretion when it comes to the statutory requirements of Rule 190, which means these are always case-by-case decision, and it's not granted that just because the court said in one case that it was proportionate, for instance, it must be proportionate in the other way. It always depends on the parties' financial means, and so on. In particular, courts are reluctant to grant overboard or exploratory requests. So what should you note in the end? Tight it as or construct your application as tight as possible, and use the arguments when you're on the other side to point out that this requirement is not fulfilled in the case at hand.